maybe I missed the memo, but there's another motion out there.
This is giving, but wait, there's more. So apparently, Lively has subpoenaed a private investigation company called Sourced Intelligence, seeking documents and communications regarding services that it was retained to provide to the Wayfarer parties or to the Liner law firm, and asking for documentations, billing records, invoices, engagement agreements, the whole lot. The problem is that Lively is seeking potentially privileged information, again, from this private and consultancy that was hired after the action commenced. So it bears to question, what is the relevance to the retaliation claim that should have arisen prior to this litigation? And the Lively side is saying, well, the smear campaign is ongoing, so you must be part of the ongoing smear campaign, and we're entitled to know everything and anything that you've said or done and to who you've said or done those things, regardless of the fact that you were hired by an attorney work product, and had communications with an attorney-client privilege. We want all of it. Sourced Intelligence provides a declaration that flat out says that we didn't perform services such as social media monitoring or influence operations or digital erasure or web monitoring identified as these relevant services by Lively. So they even provided a declaration under oath that says we didn't do any of these things that you're looking for, and the stuff that you're asking for is privileged, so no, we're not giving you any of it. But aside from pointing to the fact the Wayfarer parties acknowledged that they worked with this consultancy in some capacity at some point, there's no evidence to suggest that this consultancy did any of the nefarious work that Lively is trying to cast them to have done. Now, this is before the Central District Court of California, so this is in LA, and Lively's coming in and saying, we want this transferred to Lyman. He should be ruling on this. I agree with my friend, Not Actually Golden, that this is ridiculous. Like, everyone knows that when you file a lawsuit, if you're defending a lawsuit, if it gets to this point, you're probably going to hire some kind of consultant, some kind of private investigator to uncover different pieces of information that will help you in your defense. This is super normal. And if it were a normal case where there was really ample evidence to support the claims and there was some awareness that the other side used a private investigator, you would think like, oh, should we subpoena them? Oh, they're going to assert attorney-client privilege. It's not worth that fight. Okay, moving on to the next thing. It's not really worth, the juice is not worth the squeeze. And here it just seems like they have literally overturned every rock, everything, including rocks that should not be overturned. They're trying to overturn. And this is not the first, not the second, not the third time that they are trying to even discover things that are in the narrow category of things, privileged things that you are not supposed to be allowed to discover. So this is just another example of that. The fact that there's a declaration provided under oath that says we didn't do any of these nefarious things that you think we did, we just provided an investigation report. I mean, it's literally like hiring someone to be like, hey, can you go pull all the addresses or all the companies associated with this person or all the websites that they have in their name, their domain. Like, it's literally just a report on someone or something. It could have even been about themselves. It could have been like, hey, can you find all the places that, like, you know, my name has been used, and give me a report of that. And that's what an investigative report could look like. Now, we obviously don't know, but they're saying right here and in a declaration under oath that it's not any of these other things like social media monitoring or influencing operations or digital erasure or even web monitoring. It's like, we just, you know, researched and provided a report, and we did it at the direction of an attorney, so it's privilege. So it should have ended the conversation there. I cannot believe that a central district federal judge on September 12th is going to have to hear this matter and decide on it. And here we are.